Thank you, sir. Good afternoon, one and all present here virtually. I am Arun Verma, Head of Department, School of Law, Raffles University. I welcome you all on behalf of entire Raffles family. I welcome our Chief Patron, School of Law, Honorable Dr. Justice Meena V. Gombar, Vice Chancellor Dr. Divakar Goli, sir, all deans and heads, colleagues, students, ladies and gentlemen. Today is a great day for our university as we have a well-known personality and our revered speaker of this webinar, Professor Scott Pryor, Campbell University, USA, graced us with his presence, guidance, and accepting our request for a webinar. Professor Scott Pryor is working toward connecting young minds to strive toward success and achievement. We are grateful to him for accepting our invitation and becoming a chief speaker of today's webinar. Now I'm reading the brief profile of distinguished speaker to sincere audience. Professor Scott Pryor joined the faculty of Campbell University in the summer of 2015. Before then, he had been a professor of law at Regent University. Professor Scott graduated from the University of Wisconsin College of Law in 1980 and spent over a decade with a law firm specializing in commercial law. He represented both secured creditors and creditors committee in bankruptcy cases. Mr. Scott occasionally represented corporate debtors in several large organization cases. He left the full-time practice of law in 1995 and obtained a master's degree in theological studies before joining the academy. At Campbell University, Professor Scott teaches first-year contract and commercial law courses, including bankruptcy law, sales of goods, and secured transactions. Professor Scott served as American Bankruptcy Institute resident scholar in 2013 and has published numerous articles dealing with contracts and bankruptcy. In 2009, the Professor Scott was selected as a U.S. Fulbright teaching scholar and was posted to the National Law University, Jodhpur, where in 2010 he co-taught a UG course in contract, an LLM course in commercial law. Following this time in India, Professor Scott published an academic article titled Clear Rules Still Produce Fuzzy Results, Impossibility in Indian Contract Law. Professor Scott again received a Fulbright Research Scholar Award and this time was posted in the National Law University, Delhi, where he spent the spring term of 2019 investigating implementation of the Insolvency and Bankruptcy 2016. From his investigation, Professor Scott and Professor Dr. Risham Garg jointly authored Differential Treatment among Creditors under Indian Insolvency and Bankruptcy Code. Since returning to America, Professor Scott has lectured at programs on insolvency law hosted by Indian Institute of Chartered Accountants and the Indian Institute of Corporate Affairs. Now, I would like to invite and hand over the session to our distinguished guest, Professor Scott. Over to you, sir.
Thank you very much, Mr. Aaron, and my appreciation to all of the Chancellor, Vice Chancellor, and President of the Board of Raffles University for this opportunity. It is a great honor to me to come to know of your university and to be able to be of some assistance, I hope, of some assistance to those in attendance today. If you will have to excuse me for my American accent, I spend time in India. I probably can be better understood by my Indian students and colleagues, but I've been back in America for a long stretch of time now. In any event, I am pleased to be able to speak to you about the research that I began when I was at the National Law University of Jodhpur teaching in the undergraduate program of contract law. I was pleased when coming to India to recognize that the Indian Contract Act of 1872, drawn as it was from the British common law, was in most respects congruent with the American common law of contracts as well. Thus, it was easy for me to adapt to the Indian context, and I believe I was able to present my Indian UG students with a comprehensive understanding of at least a point-by-point understanding of where the American common law differed from the India Contract Act. Since then, I have given further thought to the place of equity, or more broadly, justice, in connection with the doctrine of impossibility in Indian contract law. Mr. Arnon, I sent a small slide deck yesterday to you. Is that something that is available to those in attendance, or not? If it is not, that's fine. I will be able to lecture with regardless. But if it is,
so it is not available with the participant, but it is available with me. So if you say,
okay.
you can say yes, sir.
All right. Well, then if you could go to what is slide number 2, there it is important simply that to recognize that I will not be talking about the entirety of the Indian Contract Act. I will instead be just centering my remarks on 3 sections of the Contract Act, sections, yes, 56 and section 56 2, 32 and 9. I will read these briefly to organize our attention in a way to the specific words that I think are appropriate here. So the second section of section 56 tells us that a contract to do an act which, after the contract is made, becomes impossible, or by reason of some event which the promisor could not prevent, unlawful, becomes void when the act becomes impossible or unlawful. This was indeed a restatement of the English common law of contracts, and entirely congruent with the American common law of contracts at that point in time in 1872. This was well understood, and indeed would have been common across, I think, any of the contract legal traditions in Europe or elsewhere. But I think 2 sections of also the Indian Contract Act are relevant, principally because, in my opinion at least, the Indian Supreme Court, your apex court, has not given them the attention it should have. And these are 2 earlier sections. First, section 32, which tells us that contingent contracts, do or not do anything, cannot be enforced by law unless and until the event has happened. In the event, if the event becomes impossible, such contract becomes void. Just by word of clarification, in the American common law of contract, these are called conditional contracts, not contingent contracts. But for legal purposes, the result is the same. So if you read in American contracts themselves, will often have a section entitled conditions. I think that's common in Indian contracting as well, but just to make you aware of that slight terminological distinction. And first, last, I guess, but first in the code, Indian Contract Act, Section 9 tells us that insofar as the proposal or acceptance of any promise is made in words, the promise is said to be express. Well, of course. Insofar as such proposal or acceptance is made otherwise than in words, the promise is said to be implied. And I think it is particularly this 3rd section here, Section 9, that has been underutilized by the Supreme Court of India when it comes to writing and making its judgments with regard to various cases of contractual impossibility. So if you proceed to the next slide, I have mentioned here 3 cases, 3 examples of Supreme Court jurisprudence with respect principally to Section 56 of the India Contract Act. And the first was in 1954. Now, of course, there were decisions earlier than 1954 dealing with the topic of impossibility, but both in the high courts of Indian states and then the Privy Council of the United Kingdom when India was still part of the British Empire. But for our purposes, I'm starting here with this judgment in 1956, the Satyavrata Ghosh case, which I clarify or I classify here as a missed opportunity. So let me explain what opportunity it is that I think the Apex Court missed in 1956. Rather than relying on the plain language of Section 56 dealing with impossibility, whether something is physically or legally possible or not, The Satamarita Ghosh case went a little bit further, or in my opinion, a little bit unclear in its analysis here. So, and I'm reading at this point simply from my published article, so please forgive me for that. So it reads here, in deciding cases in India, the apex court writes, the only doctrine we have to go on is that of supervening impossibility or illegality as laid down in section 56. I want to stop right there to say that it is not clear to me why the court did not take into account section 9, that is section 9 of the India Contract Act, which speaks to both express and implied terms in contracts. And I think it's the failure of the court to address implied terms, or the possibility at least, that implied terms could provide the resource by which to determine whether a contract party is relieved of its obligation to perform. I believe it's that failure to take into account section 9 and section 32 as well that has contributed, in my opinion, to some of the confusion that we subsequently see from the judgments of the court. And just to reinforce that point, and from that decision, from that judgment, the court goes on to write, it must be borne in mind that section 56 lays down a rule of positive law and does not leave the matter to be determined according to the intention of the parties. Having said that, that is, that section 56 and only section 56 is relevant to an excuse of a party in light of unforeseen and unpredicted events, the court has made it more difficult for itself, and for lower courts especially, to arrive at a firm conclusion in particular cases. So if we were to take section 56 literally as a rule of positive law, it's only when performance is impossible or illegal, which is rarely going to be the case. It's only when the performance by the promisor is actually impossible that promisor should be relieved of its obligation, notwithstanding the fact that the parties could have had implicit understandings based on usages, based on previous courses of dealing, perhaps even do subsequent courses of performance under the very same contract, that would have provided a basis for relieving a party of its obligation. In other words, impossibility taken solely and literally very, very much limits the opportunity for a party to be released from its obligation. In fact, maybe too strict a rule would be found if we were to determine and only determine decisions with respect to this problem under section 56. Well, a few years later, in 1960, we have the Allocate case, where the court does not, in fact, make reference to its earlier decision in Satamarita Ghosh. That, is surprising to me, but nonetheless, it's the court in the subsequent decision makes a conclusion that indeed it is possible for parties to, well, let me read again from my article, and including quoted language from the opinion here. In Allocate, the court does not apply section 56 because it is just and reasonable to excuse the promisor, but rather because on its true construction, it does not apply in that situation. Here, the apex court turned back to section 32 that I had referenced earlier, and says that justice was to be understood in the common intention of the parties. Well, the common intention of the parties obviously includes their express language, section 9, but would also include the implication that can be drawn from the situation of the parties. So the court in the second case seems more open to it drawing into the question of discharge on account of impossibility, the situation in which the parties find themselves. Well, that again is reversed, if you will, in the Nahati Jute Mills case, and a case subsequent to that one, that is Butlinga agencies. I'm not going to read from those opinions. I think that would be unduly boring and uninteresting. But my point is simply this, that reading a number of these cases and a number of others, the apex court in India has not laid down a clear rule for when a party is to be discharged on account of impossibility. It has refused and failed to follow the literal language of impossibility, and instead has suggested in some cases that the condition for discharge of an obligation can be found in the intentions of the parties, express and implied. And in other cases, particularly the third case I mentioned, the Jute case and the Butalinga case after it, it can be found in an unknown or amorphous or unclear notion of justice. Now, it is important to recognize, or I want to make quite clear at the outset, that I believe justice is an extremely important portion of the law of all that matters, including the law of contracts. But the court, your court, has not seen fit to define justice as it pertains to the question of when parties will be relieved from their obligation when it is not physically impossible for them to perform. So if you proceed to the next slide, slide number 4, I will do, the next one here, a bit of contract theory. Now, I know from my students in my American university, contract theory can often be a daunting subject. They are far more interested in learning the rules of contract law, and especially how they will be marked when it comes to the final examination papers. But I think it is important that we address the question of what theory, or theories plural, animate the contractual legal systems that we find in America and in India, because I believe they are largely the same, both drawing as they do on the English common law, and indeed drawing as they do on the longer Western legal tradition, which in this respect, I think has been widely accepted throughout the world. And this is the work that I've done subsequent to my published article. So in the American context, I cannot speak to India's contract theorists, but I can speak to those in America. There are 3 views, if you will, of what it is that makes it justified for the modern civil secular state to apply contract remedies to parties who enter into a private agreement. It certainly seems straightforward to us, but when we think about it, we understand that the civil state has authority with respect to matters of public law, criminal matters, for example, and perhaps with respect to private injuries caused by parties, the law of negligence and the like. But why is it indeed that the law lends its coercive powers to mere private agreements between private parties? It may seem unobjectionable to do so. In fact, I think it is unobjectionable. But yet, contract theorists in America have struggled to articulate exactly why it is that courts should, as a matter of public policy, enforce private contracts. And the 3 perspectives that are offered are personal sovereignty. That is, that giving remedies for breach of contract increases my power as an individual as it relates to the world around me and to other people. That is, we could have agreements without contract law. Indeed, all civilizations, I think, have had a practice of entering into contracts. But really, it wasn't until the last, perhaps half a millennium in the West, that we had an organized body of contract law which applied remedies to breach of private agreements. And for those in the sort of the liberal tradition in the West, exemplified perhaps most recently in the American context by John Rawls, it's this idea that we are enhanced as individuals when the courts give us remedies for breach of contract. Well, that's certainly, it's not false, but I'm not sure that it's complete. The second common theory, perhaps the most common actually, in American contract theory, is economic efficiency. In other words, that if we have a law of contracts which provides remedies, then we will all get more of whatever it is that we want. Our wants and desires will be satisfied. It is really a form of utilitarianism. This is different than personal sovereignty, because personal sovereignty suggests that we are trying to actualize ourselves as human beings, whereas economic efficiency says, well, we don't know what end or purpose we are putting our contracts, but whatever it is, we must want it, otherwise we would never have entered into that particular contract. And therefore, simply because we enter into contracts by adding state coercive force, we come to a position where we have more of whatever we want, whether it is goods or services. And it's important here with respect to the arguments from economic efficiency, the utilitarian arguments, that there is a great pressure for precise and clear rules. That is, we will be more effective in getting whatever it is we want in cooperation with others by means of a contract when the rules of contract law are very precise and very clear. Finally, the third contract law perspective, the one where I find myself most at home, not to say the others are irrelevant, they certainly are not, but the most important, I think, is contract approach to contract law, contract theory, is focusing on human virtues themselves. Now, in the Western tradition, we often think of the Greek philosopher Aristotle as the one who articulated the virtues of what it means to be a human being. So we have the virtue of courage, for example, and he was writing to an audience of free Greek citizens, maintained themselves in part through slavery, and of course it was primarily only to males to whom he was writing in his day, because women were not part of the political apparatus of ancient Greece. But nonetheless, he emphasized virtues which I think are common across any civilization. Those are including courage and fortitude, for example, but also including fidelity. That is, that we remain true to our word, not because it makes us a sovereign person in relation to others, not because it gains us more in terms of goods and services, but rather a just man or a just person will keep his or her word. But there is more to an Aristotelian notion of virtue, which is, for historical reasons, part of the Western legal tradition. There's also his notion of commutative justice. Now, this is a little bit more obscure, but it was his opinion that a just person would never engage in exchange to gain more than he or she was giving up. In other words, an exchange had to be fair. Of course, not precisely fair in absolutely every respect. There had to be some give and take for the nature of the market and all of that. But nonetheless, it was wrong to extract from someone else more value than you're giving up in connection with an exchange. This has been developed throughout Western legal history at great length, and I'm not about to bore you with it here, but I'm suggesting that when it comes to analyzing the question of impossibility in contract law, if the apex court in India is correct, that it is something more than actual physical impossibility that should excuse a party, the question then becomes, what is the nature of the justice? What is the nature of the equity to which the apex court is pointing when it says that the ground for, the foundation for discharge on account of Section 56 of the Contract Act is justice? What is the justice to which the court is alluding? And it has not provided a clear answer to that question. So it's my hope here to illustrate what are some of the strengths and weaknesses of each of these three perspectives when it comes to opening our understanding of what that justice, what that equity could be, in addition, of course, to the literal language of Section 56 itself. So, Mr. Arnon, sir, if you could proceed to my next slide, I will undertake to do that. We could say, if we were focusing on personal sovereignty as the motivating force of contract law, that is, that we as sovereign individuals, sovereign over ourselves and our persons, sovereign over our properties, that we display that sovereignty when we enter into a contract, and indeed enhance that sovereignty through the process of exchange with another sovereign person, we would, of course, be bound to the terms of the contract itself, full stop. In other words, a sovereign person understands that he or she is engaging in a very serious matter and will be bound by those terms as a matter, if you will, of national treaty that our modern nation states enter into. If you enter into a treaty obligation, you understood to maintain that. Of course, not all nation states do all the time, we understand, but we hold those nation states that rescind or prescind from their treaty obligations in some disrespect, so too we would hold in disrespect a sovereign individual who is not content to be bound to the terms of the agreement into which he or she entered. Now, it is also the case, and I think that all those who emphasize a party sovereignty understand that there are explicit and implicit terms in a contract. And the trilogy of resources for implicit terms in American sales law, which has crossed over into our common law of contract, but the resource for these implicit contract terms are usage of trade. I think the Indian Sales Act of 1935 is very similar on this. Usage of trade, course of dealing, and course of performance. And it's not my point here to illustrate each of these, but we understand that there is more to a written contract than the letters written on the page of paper. There is the context in which the parties find themselves, and those who emphasize party sovereignty would acknowledge that by no means, by all means, excuse me. Looking at the doctrine of impossibility from a more economic perspective, that is the utilitarian approach, would say that it is the case that we enter into contracts because we believe we are going to be better off following performance. That is, if I exchange a promise to pay some money for a cup of coffee or a cup of chai, as the case may be, that's because I believe I value that coffee more than the rupees or dollars I will be paying for it. And conversely, the seller is of precisely the opposite opinion. That is, would prefer to have the money rather than the stock of coffee or tea in his or her possession. So in other words, we enter into contracts not out of some lofty goal of enhancing our personal sovereignty, but rather to satisfy our utilitarian needs and, of course, in a consumer society, our utilitarian wants, because we want so much more than we need. In any event, the point is that when we enter into that contract, we believe that what we get will be worth more to us than what we are promising to give up. But when it comes time for contract performance, that opinion may change. That is, we may regret having entered into the contract. Now, commercial transactions, the source of regret is often the case, at least in long-term supply contracts, that the price into which we entered at point A, the market price, has fallen substantially by the time performance is due. So as a buyer, I regret having entered into that contract because, well, I could have bought it now, whatever goods these may be, on the open or spot market at a lower price. Conversely, the seller may have the similar regret if market prices rise after the formation of the contract. It will regret having agreed to sell at price X when by the time performance is due, the market value of those goods has increased to 2X. Well, those who insist on or focus their perspectival approach to contract law suggest that that, of course, is going to regularly be the case, that parties will regret having entered into contracts, but to allow contracts simply to be undone because of party regret would destroy the institution of contract in its entirety. Therefore, and they regularly use the Latin expressions, the ex ante allocation of value in the contract is more important, and that to which we should make observation and recourse. The ex ante original decision is the one that should be enforced, not the ex post regretful decision made when time of performance comes. So again, we would have, under an efficiency approach to contract law, very, very small room for a discharge on account of impossibility. It would, in fact, for both personal sovereignty and economic analysis, be the case that only physical impossibility, Section 56 in its original understanding, would be a grounds for discharge of one's contractual obligation. Physical impossibility or express terms or implied terms, but no recourse to justice broadly understood. No equitable or equitable reallocation of the exchange. Well, let's then look at the virtue approach to contract theory. That is, the virtues of fidelity and commutative justice. Well, the virtue of fidelity simply would say, yes, again, we are bound by our original contract terms, whatever they may be. We should not be relieved from them unless we can identify an express term or prove an implied term from some resource that would discharge the obligation of the promisor. But what about commutative justice? I alluded to that earlier, saying that in Aristotle's point of view, and for much of the history of the Western legal tradition, parties were expected to contract within a range of market value for whatever it was they were purchasing. This actually goes back all the way to Roman law, which had an influence, of course, in the development of the Western legal tradition. It had dropped out of the English common law, but was still present in the English courts of equity. So we have here a variation, if you will, in understanding a sort of a schizophrenic approach to contract law in the English legal system. Common law, very much about strict liability for breach of contract. The courts of equity, saying that under some circumstances, contractual performance would be relaxed. The duty of performance would be relaxed because of appeals to equity, understood in the older tradition of the Western tradition as roughly equality of exchange. Well, that might seem to be the point at which a relaxed understanding of Section 56, that is, it does not mean literally and only physical impossibility. It even including express or implied terms, there may be grounds of justice, at least the court in India suggests there may be grounds of justice that would relieve a contract party of its obligation. This would seem to be the, if you will, the point of access, the doctrine of commutative justice understood as rough equality in exchange. I've written on this elsewhere, and perhaps I will share that afterwards with Mr. Aaron. Well, that may seem to be true, but I think it's mistaken. And for this, I've come to this conclusion recently, in large part due to the writings of one of our leading contract scholars in America, Professor Robert Scott. And Professor Robert, although he's not as clear as I will try to make it now, has argued that justice has no place in contract law. Now, the system of law itself must be just, but justice has no independent application to the parties' contract. It is simply that to which they agreed as a matter of personal sovereignty or as a matter of increased efficiency. In other words, he says that principle of commutative justice has no application. I disagree with that. I believe the principle of commutative justice, that is rough equality in exchange, is extremely important, but important only at the time of initial contract formation. That is, when parties enter into a contract, let's say for a long-term supply of goods from a manufacturer to a retailer, or from an industry to further manufacturers, when parties enter into a long-term supply contract, they assume the risk that prices and values will change over the course of the term of the contract. They cannot do otherwise. We all know that matters change over the course of time. Thus, in my opinion, the doctrine of the virtue of commutative justice, rough equality in exchange, says that at the time of formation, we must pay something close to the market value of the goods. And even over the long term, we must make a fair evaluation of the risks. But we all understand that none of us know the future. And although we may have evaluated the risk of price changes going forward, we may have evaluated incorrectly. That is a regular course of human events. Thus, as long as we have made a fair valuation of those risks, even if those risks turn out to be different, we are nonetheless bound if at the time we entered into the contract, there was a fair price paid and a fair allocation of the risk of changes in the future. In other words, I agree that there is a place for justice, equality in exchange, but that applies only at the time of formation, not at the time of subsequent performance, which of course is when it is that parties seek to avoid or to the contract obligation into which they entered. So even in my understanding here of the virtues of fidelity and commutative justice, it comes to much the same conclusion as both a sovereignty account, as both a utilitarian efficiency economic account. And that gives me some pleasure to know that different approaches to the warrant, the justification for contract law, lead to the same result. And that helps me believe that that is the correct result. Well, let's advance to the next slide, and I will present just a few more words. I hope to finish soon here in terms of my remarks, opening the door to any further questions. What about a free-floating notion of justice, one that is not tethered to equality in exchange at the time of formation? In other words, what about support in the opinions, the judgments of the Indian Supreme Court for a after-the-fact equitable reallocation of risks between the parties? Well, I believe that is incorrect from a personal sovereignty point of view, because for the personal sovereignty of the two contracting parties, we have been replaced it now with a judicial sovereignty. Thus, we have undercut one of the three justifications for using state power to enforce, provide remedies for breach of purely private agreements. That is, state power is being applied here, but it's the power now of the judicial branch, that is the judge, with respect to the transaction, not the sovereignty of the two parties. The state, of course, is sovereign with respect to matters of criminal law, but with respect to private law, particularly the private law of contracts, the state's role is far the secondary. It provides a remedy, but a remedy for the party's private sovereign agreement, not a remedy based on the judge's evaluation of what would have been good, fair, or equitable. Secondly, impossibility as equity is subject to the claim or the argument that it produces economic inefficiency rather than economic efficiency. By this, I mean to say that the parties' agreement, initial agreement, by which they believe they each were coming to some mutual advantage with respect to the transaction, is rendered uncertain. Thus, parties, when they enter into agreements now for long-term supply of goods or services, must take into account that it is possible that courts will set aside that contract at a later date on the grounds of equity that would suggest to parties who are prudent that they add something to the price to take into account not the risk of future events in the marketplace, but rather future events in terms of litigation over the obligation that was expressly undertaken. Well, as much as I wish that my students will be practicing lawyers with opportunities to draft contracts and to litigate to a just result, it is not the case that I believe that the courts should increase the scope of matters with respect to which litigation should take place. That is, performance or non-performance is, of course, something that can be adjudicated in court. But whether at a subsequent date it is equitable or inequitable for a party to perform adds significant cost and delay to whatever resolution of the matter the parties would hope to achieve. And that leads then to my third point here, that as a matter of virtue, impossibility as equity creates a moral hazard. That is, that a party who is the long-term promisor, let's say, of particular goods for a manufacturing concern, that party has the opportunity, when it wishes for illegitimate reason, as well as legitimate reasons, to claim an excuse on the grounds of impossibility. And if it were held strictly to the language of Section 56, impossibility as a matter of physical impossibility, or the implied terms read in from Section 9, read into Section 32 of the Contract Act, then the range of defenses, or the scope, if you will, of the defense of impossibility would be very small. But if courts are content to apply a generalized standard of justice and equity to the duty of a party to perform, that gives that party the ability to raise such a defense and, if you will, hold its buyer hostage to the prospect of litigation. That would take quite some time and some additional expenses to get to the right result. In other words, impossibility as equity increases the possibility of vice among contract parties. That is the vice of delay, not and vice of non-performance, not because it is impossible, not because the parties' agreement provides an out, if you will, but rather simply relying on the vagaries and the delays that are associated with any judicial system. Therefore, impossibility as equity, I think, is misguided and undercuts personal sovereignty by substituting judicial sovereignty for it, reduces efficiency that is otherwise associated with free and fair transactions, and actually creates a moral hazard, rewards vice rather than virtue when it comes to performance of contracts. So if you go to the last slide, and those will be my concluding remarks before questions. But the final slide here is just two wrap-up points that I think should animate Indian courts, higher court, the high courts, of course, of the various states, perhaps even the debt resolution tribunals, and the Supreme Court of India, were the matter to reach its attention again, to utilize the full scope of the India Contract Act. In other words, not look solely at Section 56 with its very limited relief on the ground of impossibility, literally understood, but look also at Sections 9 and 32 to look at the full agreement of the parties, including terms that can be fairly implied from the circumstances surrounding the transaction. And finally, secondarily, defer to contract parties. It is not the case that contract parties are always wise or omniscient. They are not. We all understand that contract parties can make foolish decisions and can misjudge the risks that they will take with regard to performance over an extended period of time. And I'm not arguing here that contract parties are always right, but I am arguing that the judicial function should be to defer to those contract parties, not because they are always right, but because it is unclear to me that judges, after the fact, who have no experience in the field of transactions, will come to a better result than did the parties themselves when they entered into the agreement. So those are my concluding remarks. I hope this has been of some interest to you all. And if there are any questions, I will undertake to deal with them as best I can. I've seen, I think, some comments floating around here. I'm not sure I can see them. Yes, I do see some of them now here. But in any event, Mr. Randir, England is the origin of common law, exists in the U.S. Yes, we owe our common law history, as does India, for different reasons. We were populated primarily by Englishmen coming to America, many of whom, by the way, were debtors. We fail to realize that the leading founding fathers of America, from George Washington to Thomas Jefferson and the like, made use of factors in London to sell their American produce over there, and frequently found themselves in straitened financial condition. So India's experience with, of course, the British imperial powers was different than the American, but we had that common origin there here. And I think, yes, Mr. Randir correctly points out that in America, unlike India, with this respect, we have 50 common laws of contract. That is, among each state in the United States, there is an independent development of its common law of contracts. There is no unified federal court, including our U.S. Supreme Court, with respect to contract law. Our judicial system is bifurcated between state and federal. Our United States Supreme Court is, of course, the final authority with respect to all matters of our federal Constitution and with respect to matters of federal statutory law. But with respect to the private law of contracts, whether commercial or non-commercial, each state in the United States is free to develop and frame the common law as it wishes and sees fit. Thus, you would see, if you were to study law here, a marked difference at a number of points between, say, the common law of contracts of the state of California and the state of New York. And I regularly make recourse to that when I teach my first-year law students the law of contracts. I also, of course, make reference to the laws of the state of North Carolina, where I teach and where most of my students will ultimately practice. It is also the case, though, that notwithstanding some variations between California and New York and other states, that there is a substantial uniformity of the common laws, plural, of contracts among the 50 states of the United States. So it is generally fair to speak, in most cases at least, fair to speak of the common law of contracts generally in the United States. However, it is important to recognize that were one actually litigating a matter in a particular state in the United States, that recourse would need to be made to the jurisprudence of the courts of that particular state in order to find a particular conclusion. Force majeure. Yes, Mr. Arun. Yes. Well, COVID-19.
Sir, excuse me, I just add on my comment. I'm Professor Randhir Gautam, and I want to ask one question. Actually, I have just put some comments on, in the chat box, and I want to add on my comment. If you see the principle of equity, for that matter, principle of equity are regarded as a part of the common law adopted in United States. And the term common law itself includes those all doctrines of equity jurisprudence, not mentioned in legislative enactments for that matter. Similarly, a law merchant is recognized as part of common law. So it is defined as the system of rules and customs and uses generally recognized and adopted by traders as a part of law for the regulation of their commercial transactions. However, the law merchant cannot override the local law and the commercial uses of any state. Christianity, for that matter, Christianity is a part of origin of common law. Although the Christianity is not considered part of the origin of the law, common law, the courts did not regard it as a controlling or imposing in nature while discussing a religious duty of any narrow view or a thing related to morality and decency. It was observed that even if Christianity is not a part of law of land, if the popular religion of the country, then an insult to it disturb to the public peace. So my concern is the origin of common law in United States can be traced back to the various sources, such as the common law principles of England, the equity principle, Christianity, and ecclesiastical codes for that matter. And it was a very, very insightful to listen, Professor Scott. I teach sociology in the School of Raffles University. Thank you so much for your generosity.
Oh, well, thank you. Just a few comments, and I see Mr. Manasi Kumar has raised a hand. I will call on him next, but you are correct. The development of the common law before the discovery of America, before the creation of the American British colonies, involved several strands: ecclesiastical law, the law merchant, the common law of the King's Bench, and the law of the courts of equity. All of those came together, and also all of them developed in part different from each other separately. There was no substantial unifying force. We think of the King of England as having enormous power, but really, throughout much of the history of England, the king did not have such enormous power. It wasn't really until King Henry VIII that we had seen such centralizing power with the authority of the monarchy. But by the time we get to, let's say, the founding of America, the beginning of the 19th century, you're correct to note, too, that by and large, the principles of equity, the common law, and the law merchant were merged into the legal systems of the now independent American states. And this is in part because, of course, we did not have the historical feudal and resources. We didn't have the universities that were found in England. We had law, of course, but it couldn't afford to be developed as independently and as separately as we would have seen, as we had been seen in England. Thus, in the course of the 19th century, it was the case that principles of equity, which drew more from the ecclesiastical and Christian tradition, and thus of the notions of fidelity, the virtues of fidelity and justice, the principles of equity waned in the American context. and the principles of the common law courts, which were much more in favor of strict liability for breach of contract, came to the fore. And we see that development continuing through the course of the 19th and, well, into the 20th century until today, when the debate over the extent of strict liability for breach of contract versus some kind of relaxation has developed really only in the last part of the 20th century, or recurred in the last part of the 20th century. So these strands have come to, historical strands have come together. There's great historical works on this topic. They've come together, but they've continued to develop, in American context at least, in terms of the narrower construction of the common law as associated with the King's or Queen's Bench in England, and reduced scope for the principles of equity. But that has been changing, if you will, or met some greater resistance, perhaps a better way to put it, over the course of the last half century in the American context. The reason that it's become more of a challenge in the American context is twofold. One is the rise of standard form contracts, where parties, particularly consumer parties, have no power to negotiate the terms of the agreements at all, and which has only been exacerbated with the presence of online contracting, where we touch the button that says, I accept, having never read the terms, and were we to read the terms, we'd find out they're agreeing to something in a printed version, which might even be 30 pages in length. So we have this force, if you will, of the industrialization of contracts from the seller's point of view vis-a-vis consumers. And we have some sense that people are simply losing their freedom by entering into contracts, which scope of which is much, much greater than it would have been, say, 100 years ago when parties entered into contracts. So this is a live and lively topic in the American context, and I hope I've indicated my thoughts about it here. Now I see also yes, Mr. Manasi Kumar, if you would be happy to entertain a question from you.
Hi, thank you, Scott. It's Mansi, and I'm I'm a
Sorry.
woman. No worries. First of all, I just want to say I had really enjoyed reading your paper on impossibility in India. There are few people who've actually tackled Section 56 and the oddity that it is within the Indian context. I'm also an academic professor at Jindal Global Law School.
Oh,
So when I
yeah.
heard that you were speaking, I had to come, and I thank the organizers for this. I actually have a bit of a question. I think that your overall analysis of the peril the Indian Supreme Court finds itself in is absolutely right on the money. That they seem to have a difficult, sometimes tenuous relationship with the idea of intent and what the party's intent is. And from my perspective, I was actually thinking that they misconstrued the jurisprudence that was developing in England at the time that Satyabrata Ghosh came up and gave its judgment, which was grappling with the juristic basis of impossibility and the law of frustration. Because you're absolutely right that there's the express and implied intent of the parties that courts have to look at when they're trying to see whether a contract was meant to function in a particular circumstance. But at the same time, when we're speaking of force majeure and the sort of unforeseen events, at some time the English court started grappling with how artificial the entire concept was to try to find a party's intent because it was unforeseen. So how do you grapple with that? And so they started coming up with this idea of the foundation or the root of the contract or radically different obligations even after that. And I believe the Indian Supreme Court perhaps misunderstood that to mean that the party's intent had nothing to do with the analysis of foundation of the contract, whereas it was absolutely an exercise of it was not an exercise of contract interpretation, but an exercise in contract construction, trying to see the contract and what parties' basic bargain was and extrapolate from there how the parties would have intended to have it apply in this case, in the case of the unforeseen event happening. My only question, where I confess that I'm not entirely convinced that Section 32 comes into play. And that's why I wanted to hear your thoughts on this, because I think there's no way around the Indian Supreme Court trying to reach a more expansive interpretation of 56, is that Section 32 deals with the promises contracts that are conditioned upon an event happening. So a triggering event has to happen for the promise to come into existence. Whereas when we're speaking of impossibility, we're largely speaking about the discharge of promises. And so the statutory language under Section 32, while absolutely applicable in certain cases, such as Krell v. Henry, which led Pollock and Mullah to remark famously about the applicability of Section 32, but it can't overtake the fact that the Indian court has to expand its jurisprudence to sort of anchor the role of contract construction in Section 56 itself. So I would love to hear your take on that. Thank you.
Yes, well, thank you for the question and your close reading of Section 32. I have taken it to mean, I have taken an expansive reading, if you will, of Section 32 for contingent on an event not happening or an event happening. In other words, I've read Section 32 both negatively and positively, because you're right. What happens in impossibility is there's a change of circumstances between formation and performance where something has happened. And thus we have, for example, some of the cases that I teach deal with the closure of the Suez Canal in 1956, and the British, the English courts dealt with it even more than did the American courts. Well, that's the occurrence of an event. It's not the non-occurrence, if you will, of an event. But that can be phrased either way. That is, we could take that the contracts for shipping grain from United States to India, I think from the United States to Iran was the one that I teach. That is that there was an assumption by the parties that the Suez Canal would remain open. You wouldn't have to take the straight circle around the Horn of Africa. So we can characterize the occurrence as the occurrence of an event, closure of the Suez Canal, for example, as the non-occurrence of the event of being open. So in other words, but I have to admit, I'm being somewhat expansive about my reading of Section 32. The other approach that I think makes, frankly, more sense at this point is when dealing with unforeseen, unexpected events, where there is no party intent because they were simply utterly unforeseeable, is to allocate the risk of loss either strictly according to the terms of the contract. If there was no excuse, the promisor is bound to perform nonetheless. Or if we were going to relax it at all, assign the risk to the party better able to to prevent it from occurring or to ensure against its occurrence. And this is the economic, the law and economics approach that I think at this point in commercial contracts makes sense. So if it is the case, for example, I teach a case involving a long-term supply contract of coal from a coal mine in the state of Wyoming to an electrical utility in the state of Indiana. And as the coal prices increased, this was in the 1970s and 1980s, as the cost of coal increased, the Indiana Public Service Commission, which regulates prices for utilities, said that cost increase could not be passed on to the consumers of electricity in the state of Indiana. Thus, the Indiana Public Utility canceled its contract with the supplier because it could not pass on the increase in costs, and in turn bought electricity from other utilities in neighboring states. Well, of course, the supplier of coal sued for breach of contract. Clearly it was. The contract itself had a detailed force majeure clause which did not address this particular situation. So the question was, are we going to have strict liability, that is on the part of the buyer, that they must buy a certain thousands and thousands of tons of coal, or are we going to excuse them? And the court in that case said, well, we are going to do it strict liability. They have no excuse, detailed force majeure clause. They failed to address it, thus they are the losers. But the court went on and, of course, obiter dicta to say that this was still the better result, even from an efficiency point of view, because the coal mine could not spread the risk of breach because it was only a single coal mine, whereas the public utility could divert or deal with the loss that it was going to suffer by paying hundreds of millions of dollars in damages. It could spread that risk across all of its many shareholders so that it was better able to ensure or spread the disutility created by breach of contract than was the seller who had only a single coal mine. So we see in that case a strict liability, that it was not impossible to buy coal. It just was impossible to charge customers for the increased cost of coal. Well, that's a problem that buyers will always have. They don't have enough money. In this case, the buyer had enough money, but it would have to reduce dividends to its shareholders, which, that's the nature of being a shareholder. The jingle rule says you come out last. So I think either of those two approaches, that is a heightened focus on strict liability. I'll back. The first approach is to find party intent in implied circumstances. If those aren't there, which they may well not be there, then it's strict liability in my position. And if we are unwilling to do that, it's not a general equity or justice, but rather it's who it is that can best absorb, spread the cost of disutility created by breach of that contract. I hope that
So yes, that was fantastic. Thank you so much. So you actually would suggest that Indian courts may need to look beyond the express and implied term universe and beyond Section 56, which would void a contract like that, and instead create a different strand, sort of sui generis strand of evaluation of these kinds of cases, because I understand your perspective, which is that none of these cases really fit neatly within this legislative framework that we have. So the courts have a little bit of flexibility here.
Yeah, it's either no flexibility at all, which would drive parties, one hopes, drive parties to have a more explicit contracts dealing with on ever more unlikely circumstances. And in this era of big data, I think parties can do a better job of drafting force majeure clauses. When I see them in contracts, they seem to have been drafted 50 years ago and they fail to keep up with the realities of the world around us. If courts were to insist upon strict compliance with force majeure or no excuse at all, well, I hope parties would respond by drafting better force majeure clauses. If, however, and this is the argument of the efficiency theory, if we are, even though we cannot find an implied term through course of dealing, usage, trade, or the like, we will assume, perhaps wisely, perhaps not, we will assume that the parties did intend, in the face of truly unforeseen contingencies, they did intend that the party best able to bear the risk of loss should bear the risk of loss. So it is still tethered, if you will, to an implied understanding of the parties. In my opinion, that's a very thin tether at that point, but nonetheless, it's at least some way of connecting it to party intent.
Great. Thank you so much.
Okay. Thank you. Well, I've enjoyed this time very, very much. Again, thanks to Mr. Arun and others at Raffles University. It is time for me, though, to move on because I have a class in contract law later today, for which some preparation must be undertaken.
Okay, thank you so much, sir, for thank you so much, sir, for this thought-provoking lecture. We really enjoyed. And now Dr. Asuf Malik will read the vote of thanks.
Thank you, Mr. Arun Verma. A very good evening to one and all present virtually. I, Dr. Asaf Ahmed Malik, Assistant Professor, School of Law, Raffles University. On behalf of the entire Raffles University or Raffles family, would like to extend a very hearty vote of thanks to all for your gracious presence here today. I would like to take his opportunity to place on record our hearty thanks to our honorable guest, Professor Scott Fair, Campbell University, USA, who graced us with his being presence, guidance, and accepting our request for a webinar. I am grateful to the Chief Patron, School of Law, Raffles University, Honorable Dr. Justice Meena V. Gomber, for being the source of inspiration, motivation for us in organizing this series of webinars. I must say thanks to the President, Raffles University, Dr. Divakar Goli, sir. I extend my vote to thanks the active participants from different countries, the audience, students, and everyone who contribute to making this event materialize. I will be failing in my duty if I do not convey my sense of gratitude to our respective deans, HODs, my colleagues, my dear student at different school of Raffles University. So this event has opened a new vista for a thought-provoking dialogue. Finally, thanks a lot once again to everyone, and I wish you all a happy time. Goodbye, stay and safe health. Thank you so much.